right, everyone. Good morning again. And good afternoon, Judge. This urgent application hearing is in the matter of case number CFI 050-2023 and is being held by way of video conference before Justice Robert French, appearing from Australia. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by Hadaf and partner. Lead counsel is Mr. Tom Smith. Will the judge and the parties representative please confirm that the situation is as I have stated?
Yes, thank you.
Thank you. For my part, I confirm it. Thank you.
Yes,
Thank you.
yes.
Your Honour, I can't actually see you. I don't know whether you can see me.
Oh, hang on. Let me just check. I can certainly see you.
Matters then.
Well, I thought I had allowed all cameras. Just a second.
It may be me.
I think it's a glitch from the CMS, from the website itself.
Ah.
All right. Well, I can hear you quite clearly. That's amazing. I can see you and you can hear me. I guess that's as good as it gets.
That's as good as we need, I think. Thank you.
Before you begin,
yes,
Mr. Molly, can I indicate that I've read the witness statement, the application, your written submissions, and the agreement which is in issue, and then the various, I think there were various documents which form part of the rebranding strategy exercise.
Thank you, Your Honour. Very good. Well, in that case, you'll have seen that in many ways this is a relatively straightforward application, we would say. So I'm seeking an interim injunction simply to prevent, for the time being, the rebranding. The latest word from the defendant is that they intend to do that by the end of the month. They had previously indicated the middle of this month. So it may be that we can get back before you or back before a judge on a return date before they really intend to do this. The reason that there is a bit of urgency and the reason we're applying ex parte is because we are very concerned that if we tell them about the application, they'll simply take steps to frustrate an order. And there's a couple of parts to that. The first part is what they've said about rebranding so far. So if your Honour's got the bundle, previously they have said that if you were to turn, for example, to page 144 of the bundle, you'll see one of the more recent communications from their side from the 17th of July, so about a week ago.
Yeah.
And Mr. George Azar, who's the CEO of the defendant, has said, explaining a previous communication, which we can look at, we've already prepared everything from our side, and what sits with you is the website and social media, and we need to be doing together. Now, in light of previous things that have been said, our understanding is that regardless of whether we agree to this or not, they're going to go ahead with it. And shall I just show you a very few pages of the bundle if you haven't seen them already?
I think I understand the chronology of the exchanges and the positions.
Yeah.
However, that doesn't answer the question whether this should be dealt with on an ex parte basis.
I understand that.
If, for example, you were to give them notice,
yeah,
there would be a risk that if they were found to be in breach,
I've lost you now, I'm afraid.
I'm sorry, can you hear me?
Yes, I've got you now.
Yeah, okay. So if you were to send, if this application were to be made on notice, they would, if they were to proceed with the rebranding, notwithstanding the impending legal proceedings, be doing so at risk of an order ultimately requiring them to reverse that position.
That is true. I mean, the difficulty is that from our perspective, by then the damage will be done. So I understand what the court says. Sorry.
Yeah, can I just say I'm not clear on the damage. I'd just like to get my head around the nature of the relationship between the two parties arising out of the agreement.
Yes.
As I understand it, the agreement involved effectively the sale of your client's business and the transfer of a lot of staff over to the defendant. That was the sale agreement. for a price, and then there was a partnership, what was called a partnership relationship. It seems to have been some arrangement under which your client was to provide marketing and other support services to the defendant. And one of the elements of that aspect involved this rebranding strategy under clause 5G. Now, what is your client doing that they would damage by proceeding to rebrand? Your client's operating, I take it, in Dubai. Are they still carrying on the primary business? Or I thought they'd sold the lot.
So they sold the business in the sense that they handed over the marketing leads, the client base, and the sales force. They kept the marketing function themselves. So they do the marketing, they do the web marketing, and they do the electronic marketing, and they do the social media marketing. But what they also have is they own the brand, LUXHABITAT brand. So there are two brands here that have been merged into a single one, which has become LUXHABITAT Sotheby's. So essentially what is happening is you've got a valuable brand, LUXHABITAT, which is going to be left behind if the defendants rebrand. So this is a 10-year agreement. The agreement was a sale with strings. It's not just a sale.
What is your client doing with the brand?
It's attached to the brokerage. That's the point. So it's LUXHABITAT Sotheby's is the brand that is being used to develop an enormous prime property brokerage in Dubai. So if one thinks forward to the end of the contract, if the parties, my client would hope that it would carry on, but if it splits up, what will there be in 7 years' time, which will be when the contract ends? There will be two names, LUXHABITAT and Sotheby's, that will go their separate way, but the LUXHABITAT brand will have been attached to this very, very successful brokerage for a whole period of 10 years. If that doesn't happen, what happens is my client's brand just gets put on the shelf, and in 7 years' time will be valueless. So that's the benefit. It's that there's a benefit to my client's brand, which has its own status and which is owned by my client, which gets the benefit. The deal was it gets the benefit of the business association all the way through the contract. That's the
partnership payments about which you're complaining in another front.
It's not just the payments. It's not just the cash flow. It's the development of the brand. So that's what will be left at the end of the contract, and it'll either be worth nothing if it's been left behind on the shelf, or it'll be very, very valuable indeed if there's another 7 years of this level of sales. As you've seen, what was anticipated was a business that would be doing about 30 to 40 million dirhams a year. In 2022, according to the claimants, the defendants' own numbers that they presented, they did about 228 million dirhams. So they're operating something like 5-6 times what anyone expected. It's probably the result of the recent boom in property prices in Dubai, and that may or may not continue. But on any metric, it's been far more successful than anyone had expected. The deal that was done was not simply, we'll sell you our business and carry on doing your marketing for some fees. The deal that was done was an agreement to co-branding, an agreement that the brand of both companies would be carried forward for 10 years, would be developed for 10 years. And so you've got, for example, emails from the defendant where they say, we have been investing in your brand and we've invested enough. So they're just trying to effectively reverse, we say, the deal. I can show you those in a moment if that would be helpful.
Those. Can I just take you to, I just want to get the conceptual framework right. Your client is not, apart from its involvement with the defendant under this agreement, it's not carrying on a brokerage business of its own, is it?
No, it's not at this stage. Its brand is associated, is the first name on the bill for the brokerage that's being carried on by the defendant.
So the brand, as it were, piggybacks on and derives its value from its association with the defendant's business operation, which is supported by your client's marketing expertise and so forth.
Well, that's been the case. Yes, that's been the case though for the term of the agreement. So the brand itself was built before that, of course.
Understood. Yes.
And the position was that these were, my client would say, that the two leading brokerages, luxury brokerages in Dubai. During the pandemic, they decided effectively to enter into a partnership, and it's not a complete partnership of a usual sort, nor is it a merger of a company in the usual way. But the way that they affect it is on the terms of the agreement. So it's correct. So basically, in layman's terms, the defendant gets to eat my client, but doesn't get to just walk off into the sunset with my client's business. There are strings attached to that, one of which is that my client gets to keep the branding, his branding, alive during the course of that. And also he gets a percentage of the turnover.
Well, it's not, it's his branding in the sense that it's a name which originates with your client, LUXHABITAT, I think is.
LUXHABITAT, yes.
Yeah, and but its enhanced value comes from the operation of the business, which is now carried on by the defendant, albeit the marketing part is supported by your client.
Yes, that's probably, yes, I would accept that that is a fair characterization. That was the deal that was done.
Yeah, and at the end of the day, you say, right, this business being a great success, that name is a valuable property.
Yeah, absolutely, and that's been acknowledged in the emails by the defendant. They accept it's a valuable brand. Their complaint is that they have been investing too much in it, but that was the agreement.
And what the agreement subject to operation within a single market?
It is, I think, based in the UAE. I couldn't tell you off the top of my head whether it's exclusive.
Because in the email there was talk about, going into 3 markets, maybe then that's off the table and so forth.
That was discussion about entering into new agreements, separate agreements for different markets. So yes, this is confined to the UAE market. Okay.
And can we focus then on just the contractual terms you're relying on?
Of course.
Go to 5.1F first.
Yes.
And I think in the course of emails, I said having a right of the use of the brand doesn't mean we're obliged to use it, sort of thing.
Yes. Not in emails, but yes.
Yeah, that's right. So the question is, what kind of provision is G? Because this is what you're hanging your hat on, isn't it?
Correct.
So they've agreed to implement a co-branding strategy, and that's ambulatory in the sense the content of that is not yet determined. It depends upon their further agreement following the external branding study, isn't it? The external branding study doesn't actually determine what they have to go forward on. Is that right?
Correct, albeit, so there's two elements of it that I'd identify. You've alighted on the second, but the first is the co-branding strategy itself. So what that means, we say, is that it is an obligation to use both brands. And that is ultimately what is then subsequently agreed. So if we go forward to page 74 of the bundle, you'll see the email that sends across this study. But then if you go forward, for example, to 76, as part of the study, you will see what is recorded there. Once the marketing and technology partnership has been formalized, and also LUXHABITAT Sotheby's has been agreed as the new company name, we've developed this document, which has the objective and so forth. So the way it works is, A, we say there is an obligation to co-brand and therefore to use the LUXHABITAT brand. B, there is also this distinct mechanism by which the branding is agreed, and then 5.1G, the branding shall be implemented. That's the last sentence. Both parties have also agreed that the new branding will be implemented. So the implementation, there's a contractual obligation to implement it. Now, of course, the parties can agree to change the branding. Parties to contracts can generally agree to do whatever they feel. But what this doesn't permit is the unilateral amendment of the branding.
This doesn't look like an agreement to agree, does it? Or do you say the content of it, of the obligation, is determined by the branding strategy? Or
yes.
Best branding direction? Is that the kind of decision which lies in the hand of the external branding study?
Yes. I mean, well, it would have to be within the parameters of co-branding.
Yeah.
So it would have to be it would have to use the LUXHABITAT brand. And then B, I mean, I would say it has contractual content, clearly, the bit that requires them to reach agreement and then implement, because ultimately, I mean, one might say, well, what happens if they don't agree? Well, once they have agreed, one can see the commercial rationale for a requirement that the branding remain concrete, that it cannot be altered by either party subsequently, because you're looking to build a single brand which will be solid and continue for a lengthy period. So no, I wouldn't accept that it's an agreement to agree. It's one of those agreements that they will do. They will sit down and have a preliminary period in which they will reach some sort of agreement, and they will implement whatever they agreed during that in relation to the strategy for the company.
So I'm just looking at page 76. That's the one you took me to, wasn't it? I finally managed to turn the thing up.
76, yeah. So it starts at 74 is the cover email, and then 75 is the brand proposal, and 76 was the page that I mentioned.
So once the marketing technology partnership has been formalised, okay. So what had to be formalised? This post the agreement, does it?
So this is the language is a little bit strained. What it's saying is the marketing and technology partnership has been formalized and the name has been agreed. So once the marketing and technology partnership between LUXHABITAT and Gulf Sotheby's has been formalized, and also LUXHABITAT Sotheby's has been agreed as the new company name, we've developed this document. So it's not prospective, it's looking backwards, saying we've done these things, now look what we've done here.
Yeah, okay. And the nature of the relief you're seeking, does that have the character really of a mandatory injunction? You're telling them that they must continue with the current brand?
I mean, the distinction between mandatory and prohibitory injunctions can be rather semantic. I think I would characterize it as a prohibitory injunction. They're not entitled to change the position. They have to continue with what they were doing previously. I mean, you know, the distinction is important where the court on an interim basis is ordering somebody to do something which changes the position, because that is more likely to cause harm than if you just maintain the status quo. So when you look at sort of the statements from Lord Hoffman, they say, you know, there isn't actually a really, it can be very semantic when you're distinguishing between those two things. What you're really looking at is that's all part of the balance of convenience, and you acknowledge, the courts have always acknowledged that ordering somebody to do something positive carries with it a greater risk of harm than ordering them not to do something. But no, I would characterize it as a negative, a prohibitory injunction. You shall not rebrand.
Now sorry, it's hard when you can't see me, because you can't see when I'm opening my mouth, but anyway, we'll do our best. This dispute has been brewing for some time, as one sees across the sequence of emails, and you do have a what looks like a contractual mediation requirement under clause 19. Why hasn't that been invoked, and is that relevant to this application?
That has not been invoked. It is relevant to the undertaking that I can give. It's no objection to your providing me with a prohibitory injunction on an interim basis until we can come back on a return date. But what it does mean is that in cases like this, the court won't require an undertaking to start proceedings immediately, because there's a contractual obligation to go through a mediation before you can start proceedings. It doesn't stop us from asking for this sort of interim injunction. So this court has done this in the past. The most obvious one was in a hotel case where there was a tiered dispute resolution clause, and Justice Sir Richard Field was happy to give an interim order, and it didn't cause any problems. So it's an impediment to substantive proceedings, but it's not an impediment to injunctive interlocutory relief.
And I'm not quite clear on the purpose of the inclusion of the allegations relating to the alleged misstatements of
Yes.
sales revenue.
So for the purposes of today, that is simply to assist Your Honour in understanding why we're doing this ex parte. So our position being, on its face, there is very strong evidence that they're underreporting revenue. Now, quite why and how they can justify that to themselves, or whether they can justify that to themselves, is unknown. But at the moment, we would say if someone is willing to take that approach and underreport revenue to that extent, then that is another factor suggesting that if we give them notice of this, they may just go ahead and rebrand, and then the damage will be done.
That's a kind of, they're bad characters, so they won't do the right thing.
Well, we say that they've acted at the least in a way which is commercially unacceptable, and that indicates that if we give them notice, they may act similarly going forwards. So it's really about the ex parte part of it, and I understand that this court wants to be very cautious about making orders ex parte, but this is, we would say, strong evidence that there is a significant risk that if we tell them about this in advance, that they will go ahead and make it. Now, it may be that they won't. Well, in which case, no harm done. But if Your Honour accepts that there is a risk, which we say is pretty clear, given the way they've conducted themselves, then we say it just makes sense to make the order.
Now, the injunction that you were seeking would apply to their activities in other markets, wouldn't it?
So you're thinking, if we look at page 10.
I'm just looking at the second page of your draft order.
Yeah. I believe this is the entity that they use only in the UAE. I may be wrong about that, and someone will tell me. But my understanding is that when we talk about them having interest in other markets, we're talking about their shareholders having other entities which operate in those markets, and that actually this will not restrict them. I'm very happy to include some language to confine it if that's a concern.
Look, is there anything further you want to say in support of the application?
Well, there's a couple of things I ought to tell you about first, and just to make sure that Your Honour has in mind. The first is in relation to and we can talk about the terms of the order if we get to that stage, but on the terms of the order, it needs to include the provision about them having a right to apply to set it aside. That's been omitted, unfortunately, from the draft, and we'll definitely have to put that in if you make an order. The other thing I need to tell you is this, that since the evidence was filed, the defendant has reached out to try to fix a meeting, and they're not aware of the application, but they have tried to arrange a meeting on Sunday, and my clients have not responded to that, at least not positively. So what might be said as well, they're still trying to negotiate, but we say, well, and therefore maybe there's no need for an order. But we say, well, it's quite clear that they have taken off the table the rebranding, and they've said that is non-negotiable. But I bring that to your attention just in case somebody says there's significance in it.
Yeah, well, thank you.
Other than that, and they might, of course, also say that they can't act without us because we have their website and we have their social media, and our answer to that is, well, it looks like they're going to go ahead without us one way or another. And if the pain is that they have to start, they're going to need a new website eventually anyway. And if the pain is that there is some difficulty in the transition, then it looks like they are willing to accept that pain. And I mean, there are various other points that they might raise, but I think we've covered those. So that's unless there's any particular concerns that you have about the application, that we've said everything that we think we need to.
Okay, thanks, Mr. Montague-Smith. Look, my view is that whilst you have an arguable case, I think I would be much more comfortable if I'd heard both sides of the argument, particularly on the contractual obligations. And I'm not sure that the risk which your client asserts warrants me granting an interim injunction on an ex parte basis. That said, I'm happy to set an early, what I would do is adjourn the application for the injunction to a date next week, and on the basis that you serve them ASAP. And I'm looking at Tuesday or Wednesday afternoon.
Well, Your Honour, I understand the position you take. I mean, it would be a great tragedy, if I can put it like that, if we do that and they take steps. Because, as I say, I mean, if they do that, what's the answer going to be in reality? We are going to be left with, firstly, damage to the brand in the market as a result of having been dropped, because it will be announced that we've been dropped. And secondly, we are going to be left with a position where it can't really be reversed, because the effect of reversing this rebranding will be to inject such uncertainty into the marketing that it just is not going to be commercially acceptable. I understand the concerns about applying.
I don't accept that with respect, and the risk for them is great also if they end up in a situation where they're facing orders affecting their use of their proposed new brand. And if we provide a quick turnaround, then I accept that there is a risk of the kind that you say, but on the other hand, it's a dramatic matter to impose an order subject to penal sanctions without having heard from them in an area where the contractual obligations that you assert are not crystal clear. So you may have an arguable case, but the weight of the case is something to be taken into account in taking the step of making a coercive order without hearing from the party affected.
Well, I understand that concern as a general principle. I have to say I don't follow the concern in this case, and it may be that it's my failure to understand it. But given that the current proposal from the other side is that they're going to rebrand at the end of the month, it's very, very difficult to see what they would say in their favour on the balance of convenience. And I mean, it may be that Your Honour has something in your head that we ought to hear about that, but I just don't see it. And in relation to 5.1G, Your Honour says you have concerns about the construction, but again, you haven't given me a chance to deal with those because I don't know what they are. What possible interpretation could 5.1G have?
Interpretation that there is not a continuing obligation to use the agreed brand in marketing into new markets. Now, I don't think Mr. Montague-Smith is going to be assisted by us going to and fro. An interim injunction is, on an ex parte basis, is I regard it as an exceptional step to take. I know that there have been examples in this jurisdiction where it seems to be almost routine, but I don't take that view.
Well, neither do I.
And I think that we can bring this case on short notice, and that you have potential remedies if they try to do something in relation to that. And you can, of course, make that point to them yourselves. You'll be meeting with them on Sunday, presumably. The question
it was yesterday, Your Honour. No, so there won't be a meeting, I think, between now and then.
Yeah.
I mean, I think if Your Honour was able to give some comfort, some sort of direction, not direction, but some sort of indication that a step that was taken between now and if we can fix it for Wednesday, then that might give us a bit of protection. I reiterate, if there is some amendment to the branding between now and Wednesday, it's going to be a very significant harm in a very substantial industry and business. But there we are. You've made your decision and it's clear.
All right.
Is there any chance of an indication of that sort, or we just left?
Yeah, well, let me just formulate something, and then I'll if you just wait for a second. Okay, these are the orders I'd propose to make. 1, the application for interim relief is adjourned to Tuesday, the 1st of August. I'll be flexible as to whether it's Tuesday or Wednesday. I'll hear your comments in a moment. At 2:30 p.m. Perth time. 2, the claimant is to serve the application and supporting papers on the respondent within 48 hours. 3, the claimant has liberty to seek alternative interim relief in the event that the defendant proceeds to adopt its proposed rebranding in the meantime. And 4, there'll be liberty to the claimant to apply at short notice for interim relief if the defendant proceeds to rebrand. I'm sorry, I read that pretty quickly, Mr. Moses.
Yeah, I'm not sure I got 3 and 4.
Okay, I'll give it to you again.
Your Excellency, if Your Honour could repeat those, thank you. Sorry.
The claimant has liberty to seek alternative interim relief in the event that the defendant proceeds to adopt its proposed rebranding in the meantime. And 4, liberty to the claimant to apply at short notice for interim relief if the defendant proceeds to rebrand.
Thank you. As to the date, is there? Sorry, I misunderstood again. I'm afraid, because I didn't understood that Your Honour was talking about a 2 or 3 days away hearing. But is there any scope to do a hearing sooner than next Tuesday? It may be that you've considered this already.
Yes, it's
3 clear days would be the norm if it was on notice.
Yeah, the problem I have is some other commitments which I would find it difficult to get out of. I might, yeah. I'll have to. Unfortunately, it's early evening here, Mr. Montague Smith. It may be possible for me to do something on Friday afternoon.
Yep.
But I'd have to let you know tomorrow. We can hold the order off until tomorrow. We can deal with that. It's just, put it simply, I have a graduation ceremony commitment as Chancellor of the University, and I can get somebody else probably to take that on, which is listed for 2 o'clock on Friday.
Well, I wouldn't want to interrupt that, but I mean, I think you probably got a sense of the fact that we do consider there is a risk here. I think perhaps we can put it like this: the order 1 could be the application for interim relief is adjourned to either, and then insert both dates, and then the court will confirm which date is the applicable one.
Yes. Or
ASAP.
I'm hoping that, well, I framed orders 3 and 4 in the hope that that will give you some comfort in terms of drawing their attention to the defendant. Something without.
Okay. Well, thank you, and we understand that, and that's helpful. Very good. All right. So should we put both dates in the order 1, and then the court can perhaps just let us know?
The application for interim relief is adjourned to Friday the 28th of July or Tuesday the 1st of August. And in the case of Tuesday, it would be, I'd make it at 2:30.
Thank you.
I can't give you Monday, unfortunately, because there's a meeting this afternoon.
Understood.
All right. And now, have you got all that down?
I hope so, and I will liaise with my team, and then we'll perhaps send. Should we send a note of that to the court?
That would be useful. Yes.
Thank you very much, and we shall see you in a week.
Thank you. Good.